All right, and we'll go ahead and get started. Welcome to Boulder County Senior Law Day 2021. We are in our last week of webinars, and today we are here for Estate Planning 101, always one of our best topics. As you can tell, this is a virtual format. You are being recorded. This webinar will be available later on the Boulder County Senior Law Day website and our YouTube channel. And I'll post the links for both of those in the chat. Everyone has been placed on mute, so please remain on mute unless there's an emergency. Can't imagine what a muting emergency would be, but there might be one. Our presenter today is Kurt Hofgard. I've checked with him, and he has asked that you save your questions till the end. Please feel free to type questions into the Q&A or the chat box, though, and he'll address them at the end of the webinar. He's left plenty of time for questions. We do have one more webinar. It's next week. It is long-term planning or long-term care, Medicaid long-term care, presented by John Estes. It'll be Thursday from noon to 1. And again, all of this year's webinars will be available on our YouTube channel. We just need to upload them. So those will be forthcoming within the next couple weeks. We have finished our in-person Ask a Lawyer sessions, but we are excited that there is still an option to get free legal assistance through the Boulder County Bar Association Free Legal Clinic. This is a virtual clinic. You would contact the Bar Association to sign up and or apply online and get connected to an attorney for a free consult, just the same way that you would with the in-person clinic. We're excited that this is something our platinum level sponsor can offer you. We have Senior Law Day handbooks. I'm so excited. The 2021 edition just came out, and it is available at the website below. We've also made a QR code, so if you want to wave your phone in front of your screen, you can access that almost immediately to get to the handbooks. We're very excited about that. And finally, we want to thank all of our sponsors. We have our platinum sponsor, the Boulder County Bar Association, Pearl Fiduciary, and Fraser. I'd like to thank our gold sponsors, Jorgensen, Brownell, and Pepin. Our silver sponsors, Hofgard Associates and Bach Financial Private Wealth. And our bronze sponsor, Kingsbury Johnson & Love, LLC, and Friends of Longmont Senior Services. And with that, I am so excited to introduce our next speaker, Kurt Hofgard. He is an estate planning attorney in Boulder with over 27 years with his firm of Hofgard Associates. Kurt enjoys working with clients of all sizes and shapes, regardless of wealth. As a Boulder native, Kurt graduated from Stanford and Lewis and Clark School of Law. And having worked with Kurt in the past on Bar Association events, I can just attest to his care and compassion for his clients, as well as his dedication to community service. So with that, I will stop sharing my screen and I will turn it over to you, Kurt. Thank you so much.
Oh, thank you. Thank you, Brett. That's a very kind introduction. Thank you, Boulder County Senior Law Day, for everything you do for putting these events on. And I'm really pleased to be part of Senior Law Day. I'm going to go ahead and share my screen now and get this going. And we'll go ahead and get that going. All right. Well, my name is Kurt Hofgard. I'm with the law firm of Hofgard Associates here in Boulder. I'm actually a Boulder native. I've been practicing now for over a quarter century in Boulder at the same place here at the corner of 28th and Arapahoe in Boulder. Our firm focuses exclusively on estate planning. That's what I've done for now 25 plus years. A little bit about these letters behind my name. JD stands for my law degree, and I am an attorney licensed in Colorado. CLU stands for Chartered Life Underwriter. It means I have some experience and education in life insurance. And as we'll talk about today, the way you title your life insurance is an important part of your estate plan. CHFC stands for Chartered Financial Consultant. That means I have a basic understanding in how financial planning plays into estate planning. However, I'm not a financial planner. We have a great community of financial planners and financial advisors here in Boulder County that if you don't have one, I'd be glad to refer you to one. AEP stands for Accredited Estate Planner. That means I practiced in estate planning for 15 years or longer. And that's pretty much all I focus on here at Hofgard Associates. I like to really lead off with some things that you can do yourself. Especially in the last 18 months, I've had to help a lot of people do their own estate planning because they've needed it very quickly due to COVID and other situations, and we haven't been able to meet in person at times. So I like to always lead off my seminars by telling you a few things that you can do yourself and some resources for that. A couple of documents that really are important to have in place, especially as we've seen over the last 18 months, are the Healthcare Power of Attorney and the Advance Directive. And the resource I found that's best for that is an organization called the Conversation Project. Chapters of these were started up 10 or 15 years ago by the journalist Ellen Goodman in Boston after she had to go through her parents declining in old age and finally passing away, and they really hadn't made their wishes known to her. She said, well, we need to have conversations. We need to be talking about things so that people can be treated the way they want. And we have a really excellent chapter of this in Boulder County, the Conversation Project in Boulder. If you go to their website and then you go to the documents page, you'll actually see this list of all these different documents. They have just all kinds of resources here. You can look at for advanced care planning professionals, legal resources, dementia and starter kit. And the two that I'll point out right now are the Colorado Medical Durable Power of Attorney form and the Advanced Directive document booklet from the Colorado Hospital Association. This particular booklet, it's called Your Right to Make Healthcare Decisions. You might have seen that in your doctor's office or in the hospital, and it actually has a CPR directive, a living will, which is what an advanced directive is, and a medical power of attorney form. That you can follow the directions there, sign it in front of witness and notary, and actually do that yourself if you really need to in a pinch. So a really good resource is the Conversation Project. Another resource is a website called coloradocareplanning.org. That has a lot of the state's most or post programs. What's a most or post form? Well, that's a medical order where you go over this with your medical professional, either a physician or a physician's assistant. They actually sign it. It's a medical order where you're talking about if you want DNR in place or not, if you want CPR, and even some of the things that advanced directives often deal with, like if you want to be kept going or not on artificial nourishment and hydration. The most form is something that you can always do with your physician, and then you can actually go to this website, download it, and bring it into your appointment. So a couple of things that you can do yourselves. I also like to point out some other resources for people beyond the seminar today. The Denver Bar Association actually has some excellent brochures about estate planning and probate, which we're going to talk about today, if you want to go more into depth on that. They have some publications. You have to go through a little bit through their website, navigate public, and then to the public legal information, then publications. And there's several of them there. One is what is probate in Colorado? Really good explanation of our probate process, which, by the way, is one of the easiest ones in the country. In my 25 plus years of experience, I think Colorado has one of the best probate systems, very streamlined and straightforward. There's another one brochure that says, what does it mean to be a guardian in Colorado? A guardian, that's somebody who takes care of someone else who's under 18 or who is legally incapacitated. That's a guardian. There's one that says, what does it mean to be a personal representative in Colorado? A personal representative used to be called an executor. That's someone who's named under the will, and that person's job is to follow the wishes of the will and file the will with probate. Personal representative. There's one that's called what. Hello, everyone. I think I cut out for a moment. Did I come back?
Sure, this is Kyle. I can hear you again.
Okay, sorry about that. Don't know what happened there. Okay, thank you. All right, where were we? Okay, so we were talking about different brochures that you can get through the Denver Bar Association website, publications. And one of them is, what does it mean to be a trustee in Colorado? Trustee is someone who manages assets for the benefit of someone else. Other resources, of course, the Senior Law Handbook. I think it is great that this is online. That is a super resource for anything. We talked about the Conversation Project, and they also have teamed up with a hospice organization, True Care, in Boulder County. They have something called a starter kit, where you can download that, print it out, and you can start to think about this for yourself. You know, what are your wishes when you get to the end of life? Or you can go over this with a friend or loved one. We've used this with family members and clients, and it's excellent. Of course, our website has educational material, Hofgard Law. There's a great website that really goes into depth on some complex estate planning. That's through the American Council of Trust and Estate Council, also called ACTEC. They have a great site. And finally, if you really like taxes, go to the taxadvisor.com through the American Society of CPAs, their website. So a little bit there. And finally, if you need an estate planning lawyer, the first place I would look would be the Boulder County Bar Association. There are dozens of excellent estate planning lawyers listed there under Find a Lawyer. And you go under the heading of estate planning, wills, trusts, and probate. If you need another estate planning professional, like a CPA or insurance professional, and also attorneys, you can also look at an organization called the Boulder County Estate Planning Council, boulderestateplan.org. This is an organization which I have been a member of for 25 plus years. It's an interdisciplinary organization where CPAs, attorneys, insurance professionals, financial planners, we meet once a month and share ideas on estate planning and become educated and network with each other, because estate planning is not just about the attorney. That's the effective estate plan will use a team of attorney, financial planner, CPA, insurance professionals, maybe even trust officers. So some other resources for you. Okay, so let's jump right in now. I usually go to the quote section of my presentation. I'm going to go right to this quote here. Now, you might have all heard of famous people who died without making a will, or, you know, did this or that while they were alive, or didn't do this or that, and it ended up leaving a mess for their families. Well, there are plenty of stories about famous people. Here's someone who isn't so famous, but I really like to use this story in estate planning. And here's a quote from this gentleman's, one of his friends. He was a very smart man, but he died like an idiot. This is a friend of a New York man who died in 2012 with a $40 million estate, but no will and no identifiable surviving heirs, leaving most of the estate to possibly go to the state of New York. So we have a legal term for that. It's escheat. That's what happens when somebody dies without any kind of estate plan, and there's no one on the face of the earth that's even remotely related to that person. So at common law in England centuries ago, the estate of that noble person would escheat to the king. the king would get to have the estate. Now it's the state. So for all of us as residents of Colorado, escheat to the state of Colorado. That's very easy to remember. I remember this from law school, escheat. It seems like a real cheat that the state gets to have everything just because this person didn't do an estate plan. That's a very interesting situation. This gentleman was a Holocaust survivor. He came here after the war, and he married, but they never had kids. He built up a successful real estate business. His wife predeceased him, and he was actually very well connected in his community, very philanthropic. He had a great circle of friends. And his friends kept saying, you got to do something. You got to, do one of the things I'm going to talk about today. Do a will. Put a beneficiary on your 401k or IRA. Oh, yeah, I'll get around it. Well, he never did. So here we are in 2021, and they still haven't found anyone who's related to him. Is anyone here related to the gentleman? Well, if you are, get on the phone right now, because there's not $40 million waiting for you. There's 26 million, because the administrators and the challenges and the fraudulent wills that have been brought forward have taken a fair amount of the estate. So I think we're getting about to the time where it might end up going to New York, or they might have found someone from a common law marriage in Poland before the war that possibly might be able to inherit it. I don't know, but this is what happens in the worst case scenario if you don't have an estate plan. It could escheat. Now, another quote I like from Forbes magazine: there's a false mystique to asset protection planning that has often allowed planners to charge premium prices for selling cutting-edge strategies to their clients, when boring and inexpensive solutions would have worked better. My philosophy in estate planning that I've had for 25 years is that I want you to have an estate plan that works for you. Even if it's a simple estate plan, it doesn't necessarily have to be overly complex or expensive to be an effective estate plan. So, a little word on the complexity of estate plans, and how everyone doesn't need one. All right, so here I like to take a little dig at people who do their own estate plans. Use LegalZoom to create your own will. Tell me again about your years of legal experience. So there have been LegalZoom wills that have gone wrong. There was even a California class action case because of LegalZoom wills that had gone awry that people had done. Now, that said, I would always say it's better to do something than nothing at all. So it's better to do a LegalZoom type will than to have no will at all. And you can do your own will. In fact, I want to send you away with 3 things that you can do yourself as far as estate planning. The first is you can do your own will. Now, there are 2 ways to do your own will. The first is to use a program like LegalZoom or Quicken Lawyer or Rocket Lawyer. There are a lot of them out there. I don't endorse one over the other. I call them all LegalZoom wills. So, you download the program, and you go through it. There's 2 things to remember if you're going to do a will through a LegalZoom type program. First, you must sign it either in front of 2 witnesses or a notary for it to be effective. You can't just print it out, sign it, and stick it in your desk drawer. That's not an effective will. If it's printed out, then it has to be signed in front of 2 witnesses or a notary. Our practice is actually to have it in front of all 3. That is the best practice. But in Colorado, it's 2 witnesses or a notary to be an effective will. That's not necessarily the case in other states. And if it's only 2 witnesses or only a notary, there could be some hangups with probate. So 2 witnesses and a notary is what we usually recommend. That's step 1, or first thing to remember about a LegalZoom type will if you do it yourself. The second is to really pay attention and go through every screen to fill out the information. So I like to work on my own taxes using a program like TurboTax. And what I've learned over the years is if you don't fill out all the information, if you don't pay attention, you might end up with a tax return that doesn't take enough in deductions, so you pay too much in tax, or you miss an item of income and you might get audited and have to pay some kind of penalty. To have an effective tax return, you have to really pay attention and fill in all the information. I've seen the same thing with LegalZoom type wills. I've seen LegalZoom wills where the the person who made the will, called the testator, or testatrix, or there are a lot of different names for it. The person who made the will said, here's who my assets go to, the heirs, but the person did not name who's in charge, the personal representative. Well, that's not an effective will. I've seen ones with the opposite problem, which is probably even worse. It says who's in charge, but it doesn't say who gets the assets. So make sure that you go through every screen. Second way of doing your own will, this is called a holographic will. Holographic will. When you do a holographic will, two things to remember. One, you have to do the whole will in your own handwriting. You can't type it up and sign it. Holographic will has to be in your own handwriting. That's the first thing to remember. Second, if you do a holographic will, then you have to notify somebody of where it is. Someone other than you needs to know where it is. That might seem obvious, but we have clients who we've started estate planning with, and they call me up. They're on their way to the airport, and they say, "Oh, we're going scuba diving. Is there anything we can do? I know we haven't finished our estate plan." And I say, "Well, yeah, you can do a holographic will. You know, you could do it on a napkin or any kind of spare piece of paper. So one, do it in your own handwriting so that it doesn't have to be witnessed or notarized. If you do a holographic will, it does not need to be witnessed or notarized. Two, don't take that on the airplane with you, because that won't do much good if you and the airplane go down. So you can do a holographic will as well. Now, do I think that either a LegalZoom will or a holographic will is as effective as engaging an estate planning attorney for your estate plan? Well, I might be a little bit biased, but this is my field of expertise. I've done it for 25 years. I can probably spot things that clients haven't and really get you the right plan. I compare it to other things that people do themselves. So I learned a long time ago that I'm not a very good auto mechanic. When I tried to take apart my family's lawnmower engine for a shop class when I was in junior high school, that lawnmower never went together again. So when I need work on my car, I take it to a professional that knows what to do with that. You know, people tell me all the time, well, you can do your own research on the internet. You know, that's great. Well, some things might be a little bit too important for that. For example, when you have a toothache or a cavity, do you get on the internet and try to fill your cavity or, you know, do your own dentistry? No, you go to a dentist. Well, something as important as your estate plan, where your assets will go after you die, how you will be treated if you're alive but disabled, something that important is, I think it's worth going to a professional. All right, so next part of our presentation, we're going to talk about effective estate planning and methods of effective estate planning. First, we're going to answer the question, what is not estate planning? The answer to that is there is nothing that is not estate planning, kind of a double negative there. So a little bit of a trick question. Why is that? That's because of the two facts of life. I bet people have heard the two facts of life, quoting Benjamin Franklin. There's nothing certain in life except death and taxes. Death and taxes, two facts of life. Well, I have a little twist on that. The first fact of life, same as what Benjamin Franklin says, death. That's a fact of life. 1 out of 1 people die. That's the statistic on that. Second fact of life that's similar to taxes, but a little different, is the fact that everyone has an estate. Everyone owns property. You might think the estate is only within the purview of the very wealthy. Only wealthy people have estates. Well, that's not true. Your estate is the property that you own. Your car, the clothes on your back, your house, your investments. These are all assets. These are all types of property that are in your estate. So we have these two facts. Everyone dies. Everyone has an estate. The question is, that we're going to answer with estate planning, who has the right to the asset of someone who has died? Now, you have the right to make those decisions. And if you haven't, there's a set of laws that says who has the right to your assets if you don't have an estate plan and you die, when you die, because everyone dies eventually. These are called the laws of intestacy. When someone dies without an estate plan, they've died intestate. Every state has a set of laws of intestacy. Colorado's laws of intestacy go something like this. If you're married, it goes to your spouse. If you don't have a spouse, but you have children, it goes to your children. No spouse or children, it goes to your parents. None of them there, goes to your siblings. They're not there, it goes to your nephews and nieces. None of them there, it goes to your aunts and uncles, all way out the family tree. So as far as you can. And then if no one on the face of the earth can be found, then it will escheat to the state of Colorado. So that is an estate plan that everyone has, even if you haven't done anything. So we all right now, right here, have an estate plan. There's nothing that's not estate planning. The question is, what is effective estate planning? Let's talk about what's in your estate first to try to get to effective estate planning. And this is the process that we go through with our clients and prospective clients. We do offer a free half-hour consultation via Zoom or phone to anyone who has come to the seminar today. And I encourage you to take advantage of that, or contact one of my colleagues with Boulder County Bar Association. You can see a whole list of estate planning attorneys there. And this is the process that we would go through with you to talk about what kind of estate plan we would recommend. We're going to look at the assets in your estate. How is the asset owned right now? How much is it worth right now? How is it designated to pass right now? Let's get into more detail on what some of the assets may be in your estate. First one that most people think about is real estate. So that includes your primary residence, and it also includes rental or vacation property. And here's some of the questions we're going to ask about that. Does the property have a mortgage? What's the fair market value of the property? Where is the real estate located? Is it in Colorado or another state or country? Now, if you have real estate in another state, that would be a reason we might recommend what's called a revocable living trust. Revocable living trust. The main purpose of a revocable living trust is to avoid the probate process. Now, in some states, that probate process is very expensive and time consuming. One of the worst violators I've seen is California. So if I was doing the seminar in California, I would be recommending that everyone should have a revocable living trust to avoid the California probate process. How does a revocable living trust avoid the probate process? Well, basically it goes like this. Let's say I, Kurt, own property in California, a condo in Lake Tahoe. Well, I'm a resident of Colorado. If I die just owning that California property, my estate will be subject to Colorado probate, but that real estate will be subject to California probate. Real estate is subject to the probate where it's located. So there would be two probate processes. Now the Colorado probate's easy, not worried about that, but I don't want to have that California probate process. So to avoid that, I will set up a trust, an arrangement. It's called revocable because I can change it whenever I want. It's a living trust because as long as I'm around, I can change it, put things in and out of it. I control it. I'm the settlor, I'm the trustee, and I'm the beneficiary. Now, how does this avoid probate? Well, once I've transferred my property into the trust, let's say I die after that. When I die, the owner of the property did not die. The trust is the owner of the property. The successor trustee I've named there steps up and distributes the property the way I want, according to my trust. And voila, we've avoided California probate with using a revocable living trust. So that's one of the main reasons for that. A little aside there on revocable trusts and one of the main reasons to use them. Other questions with real estate. Do you own it with someone else? Who and how? There's a couple of ways of owning real estate. We're going to talk about it in a moment. Is the real estate part of a business, part of an LLC or corporation? If that's the case, then there's some special considerations. All right, next asset most people think about are their retirement plans, qualified retirement plans. So this includes IRAs, also includes employer-sponsored plans like 401ks, simple SEPs, 403b, 457 plans. It includes pensions, defined benefit plans. So here's the question we're going to ask on retirement plans. Who are the primary and secondary beneficiaries? And here's the second do-it-yourself estate planning technique that I'm going to send you away with. You can actually check your beneficiary designations on your retirement plans. You know, it would be who you have your IRA with, your financial advisor, or with your employer for your 401k. And you can check, who did I put down as primary, secondary beneficiary? And if you haven't put somebody down as primary, secondary beneficiary, here's your chance. Go ahead and do that. Because that asset will go directly to that beneficiary. It actually goes outside of any will or trust, directly to the beneficiary. Here's something that a lot of people don't know. The beneficiary designation supersedes what you have put in any will or trust. So, I've come across this problem before. Single person has some life insurance. Person says, okay, I'm going to put my brother is the primary beneficiary and my sister is the secondary. Person who has no kids, not married. Person goes on his way. He says later, well, I think I'll do a will, and I'm going to do it on LegalZoom. That lawyer told me to look at every screen. All right, I'm looking at all the screens. Oh, life insurance. Do I have life insurance? Well, yeah, I do. Well, my will, I think I'll put my sister first. I changed my mind. I want her to get my life insurance. So this person has done a will later, and they signed the beneficiary form. All right, person dies. Guess what? Well, the will doesn't matter in that case. Beneficiary designation supersedes. So, important thing to know about beneficiaries. Beneficiary designation supersedes what's in any will or trust. So important to have primary and secondary beneficiaries on these types of plans. Next asset most people think about might be life insurance and annuities. My father was a life insurance professional, and he used to say life insurance might not be a great way to invest money, but one thing it does, it creates an instant estate. So that is money that goes income tax free in most cases to a beneficiary instantly, almost right away after somebody dies. With life insurance annuities, it's the same as with retirement plans. You want to make sure you have primary and secondary beneficiaries, because that death benefit will go directly to those people. Those people, you don't have to open probate if there are beneficiaries listed on life insurance, and if that's the only asset. The person who's the beneficiary simply would fill out a claim form and send that in with a death certificate to the insurance company, and then the insurance company would release the money to that person. Great way to do some basic planning. Next asset, business interests. So maybe you're in business on your own, you're what's called a sole proprietor, or maybe you've taken advantage of one of these limited liability entities, a corporation or an LLC, limited liability company. I almost always encourage people who are in business on their own to go ahead and set themselves up as a S corporation or LLC. And I have several colleagues that work in business planning as well, that I refer people to that for these things. If you're in business with a partner, you should have what's called a buy-sell agreement in place. And of course, if you have business interests, make sure you have the right kind and amount of liability insurance. Other intangible personal property, that'd be like after-tax investment portfolios, mutual funds, stocks, bonds, money market, checking and savings CDs, college savings plans like 529 plans. These are also assets that are part of your estate. And finally, we have tangible personal property, vehicles, jewelry, family heirlooms, artwork, collectibles, musical instruments, pets. So you can actually designate who gets your tangible personal property with something called a personal property memo. This is similar to the holographic will, where you can actually write out in your own handwriting who gets what items of tangible personal property like this. And in the wills that we draft, we call out that personal property memo at the beginning of the will. We say, all right, if I've done one of these, go ahead and distribute these little items first, and then you'll get to the big stuff that the will distribute. My piece of advice on this from my experience is, if you think that your kids or your heirs might fight about your personal property, make sure you do one of these. If they don't really care or you don't really care, well, maybe not. But if you think there might be a fight, make sure you have a personal property memo in place, because I have seen some very nasty litigation cases from my colleagues. I don't do litigation, but I've seen cases where people are spending thousands on lawyers over tangible personal property of an estate. I saw one colleague gave me a war story about 4 siblings, each with their own attorney, fighting over a University of Michigan alumni mug. You know, all the parent had to do was do a personal property memo. Joe gets the mug. That would have taken care of it. So a little word about that. All right, so now we've taken inventory of what's in your estate. Now we need to determine the size of the estate, and we're going to look at the net amount. So we're going to add up everything and minus out any debts, mortgages, large credit card debt or auto debt, things like that. But do remember, include the death benefit of life insurance. That is part of the taxable estate as well. Then we're going to ask the question, is the estate taxable or not? Well, most estates that I deal with right now are not taxable because the amount of assets you have to have for your estate to be subject to the federal estate tax is 11.7 million for a single person, or for a married couple, twice that amount, 23.4 million. So I don't do as much estate tax planning as I used to. Here's a chart that shows how the estate tax has gone. You know, back in the mid 90s when I started practice or so, the amount was 600,000 for a single person, 1.2 million for a married couple, and the top estate tax rate was 55%. Well, fast forward to 2021, here we are now, 11.7 million. However, there are some changes coming. We'll see. I don't have a crystal ball, but this is what's being worked out right now in Congress, is actually possibly bringing the taxable estate level back. And what they're thinking about doing is index for inflation, what it would have been under the law in 2017. And then beyond that, who knows? So if, in other words, if you're combined estate, if you're married or in a partnership with somebody, if your combined estate is over 12 million, then you might have to think about the federal estate tax. Or if you're single and your estate is over 6 million, then you might have to think about it. So to be determined, I like to tell people, because right now everything is kind of in flux. All right, so we've been talking about marshaling assets or figuring out what your assets are. Now we're going to step back for a minute though, and think about who you're really planning for. Are you married, single, domestic partners, widowed, divorced, remarried? Do you have children or not? And if you have children, are they minors or not? In other words, are they under the age of 18 or not? So I think of children in three different categories: minors under the age of 18, or I call young adult children, which can be anywhere from 18 to 60. What's the definition of a young adult child? It's somebody who's technically an adult. They're over the age of 18, but it would be a bad idea for whatever reason for them to inherit a lot of money outright. So for minors or young adult children, then we will usually recommend an estate plan that has a will with a testamentary trust. Will with testamentary trust. That means what we'll do, this is different than the revocable living trust we talked about a minute ago. Testamentary trust is a little trust that's part of a will. And so, for example, husband and wife come to me for estate planning. They have minor children. We'll set up a estate plan normally for them where the wills would give everything to each other. But if both parents die, the assets would go into a trust for the benefit of the children. And we usually have the age at which the children can get the assets outright, not be 18, because that's why we want to do this trust, because that idea for an 18-year-old to get a whole bunch of assets all at once. Without any kind of will, someone who's 18 has the right to own property and inherit. So without any will, if a married couple like this dies without any estate plan, then when the child gets to be 18, the child has a right to his or her share outright, do whatever they want with it. So not always a good idea. So instead, we would set up a will with a testamentary trust, and a trusted family member, maybe one of the spouse's siblings or someone like that, can step in and manage the asset for the minor or young adult child until a certain age. Or maybe you do have grown children, which means they would be fine just inheriting everything. In that case, we might not even use trusts at all. Do you have children from previous marriages? There's some special planning that has to be done around that. Are you planning for grandchildren? Do you have charitable intent? Do you want assets to go to nonprofits? And if you want assets to go to nonprofits, you definitely have to take advantage of one of the methods we're going to talk about now. I also like to mention estate planning. I've been talking about death all this time, but effective estate planning is also planning for possible disability, making sure you have medical power of attorney in place so somebody can make healthcare decisions for you if you're disabled or incapacitated. Making sure you have financial power of attorney in place so someone can make financial decisions for you as well. All right, so 4 methods of estate planning, 4 methods of transferring property at death. The first one is called by operation of law. And really what this means is the property in joint tenancy or not. And the main property we're thinking about here is usually real estate with partners or a married couple. There are 2 ways that 2 people can own real property. Joint tenancy and tenancy in common. Well, what's the difference between those 2 ways? Well, let's talk about that. So if 2 people own property as joint tenants or joint tenants with right of survivorship, that's the same thing. Then if one of the joint tenants dies, the surviving joint tenant automatically gets the property outside of any will, outside of any probate. Very good way for people at the same generation, married people or partners, not parent and child. I do not recommend joint tenancy for that, but people at the same generation level. Great way for people to own property and do some basic planning, joint tenancy. Typically with a married couple or partners, we will recommend that they hold their real estate in joint tenancy. There might be reasons not to, which we can get into in your situation if that's true, but normally we want them to own the property in joint tenancy so that if one of the spouses dies, the survivor doesn't have to admit a will to probate to move the house to himself or herself. It goes to that person by operation of law by joint tenancy. What if 2 people own property as tenants in common? Well, when one of the tenants in common dies, that person's half goes according to his or her will. It does not automatically go to the tenant, the surviving tenant in common. So you can see that there's a big difference between the 2. Now here's the third do-it-yourself thing you can do. You can see if your property is in joint tenancy or not if you own it with someone else. How do you do that? Well, you can either look at the deed from when you bought the property, and it's actually signed by the person who sold you your house. You can look at that deed, and you and your partner will be listed as the purchasers or buyers. And then after, your names will be as joint tenants or as joint tenants with right of survivorship or some variation where it says joint tenancy. Those words need to be there for that property to be in joint tenancy. If that magic phrase, as joint tenants or some variation, is not there, the property is in tenancy in common. So you can see this makes a big difference. Now you can also look at your deed. If you live in Boulder County, you can pay like, I think $2.25 on the Boulder County Clerk and Recorder's website, and you can download a copy of it as well. You can search for your property that way. So you can see how important this is. It's easy to fix if you want to put your property in a joint tenancy with your partner. You can just file a deed that does that. Not a big deal, but important that you have that clear whether you have your property in joint tenancy or not. When I'm talking about operation of law, I also like to mention another way of passing property. That's called the beneficiary deed. I've been doing more and more of these. With the beneficiary deed, you can actually file a deed ahead of time with the county clerk and recorder that says, when I die, I want this person to inherit my real estate. And that operates like joint tenancy. That will go automatically to that person outside of any wills or trusts. A great way to do some basic planning, but not for everyone, because if you change your mind later on that beneficiary deed and you want it to go to someone else, you have to proactively file a new beneficiary deed. Whereas if you do your planning through a will, you don't have to file that will with any governmental authority. You can just change your will. All right, second way that property passes, we've already talked quite a bit about, is by contract. That is the beneficiary designation. With retirement plans, life insurance, annuities, more and more, you can do another kind of beneficiary called a payable on death or transfer on death designation, POD or TOD. And we've already talked quite a bit about this, and I emphasize again how important it is to make sure that you have primary and secondary beneficiaries on these top 4 assets, or top 3, retirement plans, life insurance, and annuities. Third way, probate. So now we're going to talk a little bit about probate. When we have probate, the person either had a will, that's called testate, or they did not, called intestate. So 90% plus of cases in probate in Boulder County are unsupervised and informal. Now, sometimes you get to the supervised formal stage or kind of probate where you have a will contest or something that's being challenged. Well, those are actually not the majority of probate cases. The default here is unsupervised informal probate. What is probate like in Colorado? I like to say it's 5 days, 10 steps, 6 months. Again, the reason for probate is our 2 basic facts of life. Everyone dies, everyone has an estate. So we're trying to answer who has a right to the assets of the person who has died. And probate is the set of laws that says here's who has the right to that, so that the person who is inheriting can take title to that asset. And when you can either pass your assets by one of the other ways we just talked about, by joint tenancy or beneficiary designation, or you can do it through your will and have it subject to probate, which is not a big deal in Colorado. Okay, Colorado probate, very easy. I don't routinely recommend people spend thousands of dollars for trust planning just to avoid Colorado probate. That's not something I recommend. Other attorneys might have a different philosophy, but that's been my philosophy and from my experience and also as a probate attorney. So that's the reason for probate, 5 days. So you have to wait 5 days after somebody dies. Can't open probate before 5 days. Then probate has to remain open for 6 months. And then here are the basic 10 steps of probate. Personal representative gets appointed by submitting the original will and some forms to the probate clerk in the county where the person died. Every county in Colorado has a probate clerk. That's part of the district court system that accepts the wills, original will and some forms. Assuming everything's in order, within a week or two, the probate clerk will send the personal representative something called letters of administration. I call that the magic piece of paper. That gives the personal representative the authority to deal with the estate, and that's the end of the court involvement. So no hearings, no judges with unsupervised, simple probate. Here are the next steps. Honor the last wishes of the decedent, burial, cremation, so forth. Make sure that guardians get appointed for any minors if that's necessary. Marshal the assets and inventory the assets. Maintain the estate. Pay the electric bill and so forth. Deal with any creditors of the estate. Sell the property. As soon as the personal representative is appointed, the personal representative can list the property, can sell it, can even make distributions. It's not like some states where there's a waiting period. Colorado is very easy that way. Pay any taxes and prepare an accounting. Distribute the property to the individuals or trusts under the will, and finally close the estate, which has to remain open for 6 months, but often remains open longer, especially if there's property to sell. All right, so probate, very easy in Colorado. Final way that property transfers, the 4th way, is by trust. And we've talked about 2 different kinds of trusts today. The parties in the trust are the person setting up the trust, called the grantor, settlor, or trustor, and that's the person who puts the asset in the trust. There's the trustee, the person who manages the assets for the people who are named under the trust, and those people are the beneficiaries. Now, we have 2 different kinds of trusts we talked about, the living trust, and we normally deal with revocable living trust. That's when you set up a trust while you're alive and you put property into the trust, the main purpose of which is to avoid probate. And we also have the testamentary trust. That's when you have a little trust that's part of a will, and it only goes into effect when the person has died. It's not funded during life. And the main purpose of that is to manage property for minors or incapacitated or young adult children. All right, ultimate 2 questions in estate planning as we wrap up here that you're really going to be asking yourself. Who is in charge? In Colorado, that's called the personal representative. And where do the assets go? Individuals, trusts, nonprofits. Basic estate plan, everyone should have in place. Everyone should have a will. Or if you have minor and young adult children, will with testamentary trust. And with minor and young adult children, you will also name the guardian who takes care of the child until the child's 18, and then the trustee who manages the assets for the benefit of the children and the ages at which the children have a right to the assets. And then any will answer the two questions: who's in charge, the personal representative, and backups in all these positions, and where do the assets go. Second document, financial power of attorney. So that's the document where you state, if I'm disabled or incapacitated, here's who makes financial decisions for me, and a backup. So here's who's going to pay my bills, make investment decisions, make sure things don't fall apart financially for me if I'm disabled. Healthcare power of attorney, person to make healthcare decisions for you if you cannot give informed consent to your healthcare decisions. And again, that's one of the forms you can actually download and do in a pinch quickly if you go to the Conversation Project website. The HIPAA authorization. In our practice, we like to have a standalone HIPAA authorization, the privacy law that says your information can't just be shared with anyone by healthcare providers and entities. Well, the HIPAA authorization says, well, I want to make sure that these people can get information, that if I'm in an accident and I end up in a hospital where I've never been before, and my family comes there, the hospital, the doctors and so forth don't tell my family, they don't say, we can't give you any information because that would be a violation of HIPAA. Well, my family should be able to produce something that says, but here is something that person signed that said, hey, all you doctors and hospitals out there, these people have a right to see my information. Don't withhold my healthcare information from these people. Finally, you have what's called the advance directive or living will. That's where you get to make the end-of-life statements on life, on whether you want to be kept going on artificial nourishment, hydration, if you want to be taken off those things, you want to be kept going for a certain number of days, do you want to be kept going indefinitely? Do you want your healthcare power of attorney to make that decision, or do you want to make your decisions known in this document, make that the binding decision? That's the basic estate plan everyone should have. Don't forget, though, to take advantage of a couple of the other methods to make sure your property is in joint tenancy, if you want it to be that way. And once again, make sure those beneficiary designations are lined up properly. All right, I'm going to go ahead and stop there and go ahead and take some questions. I will open up the chat and the Q&A. I'll start with the chat. Okay. A question from the chat: do you help with trusts? Do you manage trusts? What are the costs? So yes, as an estate planning attorney, I help people set up trusts of all different types. Do you manage trusts? Well, typically, it won't be the attorney or the law firm that will be the trustee of the trust. It will usually be a trusted family member or a financial institution, or maybe a professional fiduciary like one of the sponsors here, Pearl Fiduciary, who would be in charge of managing the trust. What are the costs? Well, there would be costs to have the attorney draft the trust. You know, a typical trust, I don't really have a set fee for everyone. We try to do fixed fee planning, but I've learned over the years to not actually throw out numbers at the seminars like this. This is where I say, well, I'd like to talk to you about your particular thing. And then once we've talked through everything, then I can quote you a fixed fee on the estate planning. We do offer that free half-hour consultation. My information is right here, Hofgard Law. If you just Google the name Hofgard, you're going to find me because it's such a funny name. You know, you can always contact us and be glad to set up a free Zoom or phone consultation with you to talk about that and any of these other questions too. Here's a good question. How do you handle interactions with clients to handle the pandemic, dealing with Delta variant? Yep, that's a very good question. So our practice is everything is done via phone or Zoom until signing. When you sign the document, you know, some attorneys have gone to remote notarization and witnessing, and that seems to work. I have found the regulations and so forth way too burdensome for remote notarization. So what we're doing is if the clients are vaccinated, we will see you in our conference room, and our staff is completely vaccinated. If the client's vaccinated, we'll see you in the conference room with masks on, socially distanced. But if you're more comfortable, or if the client's not vaccinated, then we actually can watch you sign outside. We have a whole system for doing that as well. And with the witnesses, we supply the witnesses and notary too. So excellent questions. So now I'm going to go to the Q&A. Okay, will all these resources be available to us? I believe the answer is yes, because this session was recorded. So once it gets downloaded on YouTube, go to YouTube, and then you can just go right through my PowerPoint. It'll come up on your screen. You can pause it and go to all these resources. And you can always contact us too, and we're glad to send you the PowerPoint presentation.
And Kurt,
Yeah.
since you did this same presentation last year, were some of the same resources already in there, or have those been updated and changed?
Some of them are also in there as well, and those are still good resources. I've just made it even better this year, but you can certainly look at last year's presentation as well. Yeah, good questions. All right, I have a reverse mortgage. What is the best way to pay for that? Well, that is a financial planning question. So if you have a financial planner, I would bring that up with your financial planner. If you don't, then that's something that I could give you some resources on who you can talk to about that. Here's another question. Upon death, how and who satisfies the mortgage? If the asset for the mortgage is divided between several nonprofits, how is that handled? Then is one given beneficiary designation, the other secondary? Who satisfies mortgage when in control to sell and satisfy designations? All right, so several questions here at once. Who satisfies the mortgage? Well, when someone dies and that person had a mortgage on their real property, the bank or credit union or mortgage company is what's called a secured creditor. So that person has the right to get the mortgage. Now, typically, the property will be sold and the mortgage will be paid off, but doesn't have to necessarily go that way. If you want it actually distributed to heirs, the heirs will have a right to take over the mortgage. There's some cases where they can't, but in most cases, they will have the right to take that mortgage over. But they do have to keep the mortgage going. In fact, that's part of the state administration and probate, is making sure the mortgage gets paid so that it doesn't go into foreclosure. And then if you do it with beneficiary designations, you can have primary and secondary beneficiary designations for the beneficiary deed. And I think I answered that question. Another mortgage question. Does one beneficiary on the list of nonprofits have control over the others? Okay, so let's say you have a scenario where you've named in your will several nonprofits as the beneficiaries, and you've done this in your will, and let's say the only asset you have is a house with a mortgage. Well, you will have also named a personal representative or executor in your will. And your will might say you have to distribute the property to the nonprofits. I wouldn't recommend that. Or your will says, whatever is in my net estate, I distribute to my nonprofits. Then that would allow your personal representative to sell the house and then distribute the net proceeds in the percentages you've named in your will. That's the way to go about that. Hopefully I answered that question. All right, I'll hang out here if there are any other questions now. If you want to type those in, or I don't know if Kyle caught any that I did.
No, I think you got them all. And I have to say, I applaud you because it is 12:59. You got them almost exactly within the time frame. So that is an impressive skill. Almost never happens that way.
Oh boy, I'm lucky.
Well, Kurt, I want to thank you again for presenting today. This is such a meaty topic and such a really good presentation. And you've done a really good job of just making it digestible for folks.
Thank you. Yes, it's been a pleasure.
Yeah, and with that, I just want to say thank you to all of our attendees. Please sign up for our last one, which is on Medicaid long-term care planning. Another really meaty and mysterious sounding topic that our speaker, John Estes, will parse down into an understandable chunk. So, and we do have one final question to take us out.
Okay. Why would you not encourage allocating nonprofits? Didn't quite understand what was said. Okay, so I will have to say this would be something I'd be glad to talk to you about, because we could get into that. Sorry to punt on that one, but it takes a little bit more than just a couple sentences.
Well, and on that note, I think that explains why 27 years of experience is important in this field. Thank you so much, and everybody, please have a great rest of your day.
Thank you.
Take care.